What's going on, YouTube? You tapped in with your boy Big O, watching another episode of UTV, the TV you can feel and see. And just as promised, I'm going to keep y'all up to date with all the FBG BUTTA / OBLOCK 5 murder case files as they come, when they come. But if we take a brief look and just check out the docket entries, as y'all can see here, the last entry was December 5th. Today, the 7th. If I refresh that real quick so y'all can check that out. As you can see here, no more entries. But guess what? We got the back door, y'all. We gonna go ahead and check out that docket sheet. And what I want to check out is, bam, I already got it queued up, just to let y'all know. Womp. Bam. And we got it just like that. I already got one of them queued up. I read a little bit of it, y'all. But we got yesterday's paperwork. It ain't got nothing to do with butter. Well, the one I read ain't got nothing to do with butter. I ain't seen 396 yet. I did see a 396. No, it was 392 that's sealed. But I'm going to show y'all something about those sealed documents here in today's video. People was like, man, how is you getting these sealed documents? Well, I'm going to show y'all a little something here in today's video. But check this out. We already got that one queued up, so I ain't finna pay for that again. That's 70 cents. Not much, but again, though, I'm not about to do that one again. I already got it queued up. Here we go, though. Now, it states, prior to trial, the government filed a notice and motion to introduce evidence under the Federal Rule of Evidence 404B, docket 209. Let's go check out that docket on 209 to see where it's at. But let me show where 209 real quick. As y'all can see here, 209 miscellaneous relief. It isn't a sealed document. So let's check that out. While we waiting for that to queue up, let's continue reading. Among other things, the government sought to introduce evidence that Tacarlos Orford knowingly submitted fraudulent pay stubs to a car dealership in order to obtain the Ford Fusion that was used in the shooting of Carlton Weekly. Let me make that a little bit bigger for y'all. Okay, after the court's order, counsel for Orford told the jury during opening statement that Orford believed he had done everything he needed to obtain the car and falsely suggested that Orford's lawful purchase of the car should be considered as evidence he is not in a gang or a murderer. Okay, as contemplated by the court and described further below, defendants have opened the door to introduce of testimony regarding defendant Orford's fraud, and such testimony should be admitted. Okay, the court considered the government's notice and motion to admit on multiple occasions. In the end, the court ruled that government's exhibits related to the car purchase were admissible, including to the extent they indicated Orford's car loan had been denied because he was no longer working, but the government could not elect. I don't know if I'm saying that word right, but I know y'all be on a nigga back if I mispronounce a word, so don't kill me. Testimony regarding fraudulent alterations and submissions of pay stubs. So I guess just a summarization. I'm going to exclude the evidence of fraud in the purchase of the car on 403 grounds. The government, so basically they trying to throw out the whole evidence that the nigga got his car through fraud. That ain't even too big of a thing to be even for the prosecution to even be going after, if you ask me. I mean, it does sit in the, and this argument isn't being said in front of the jury, by the way. So that's why they arguing like, man, we shouldn't let them bring this up in front of the jury. I mean, it doesn't really matter how he obtained the car. It's enough evidence, man, to know who did what. So Tacarlos Orford bought this Ford Fusion. He went into a car dealership. It had 126,000 on it. He paid $35,000 down. Damn, boy. They be getting down on niggas. He still paid 35,000 down, but that bad boy had 126,000 miles. They want him to be a murderer and a gangbanger and a killer and all that. He went in. He didn't carjack somebody because he wanted a car. He went and put down 3,500. This is what his defense is saying. He signed the paperwork and he drove out the last week of July. On August 3rd, about a week later, before any idea of a shooting, the dealership and the salesman said, your financing fell through. You don't have the loan. You have to bring the car back. Does he fight with the guy? Does he refuse to bring the car back? No. He says, I'll bring the car back. He was disappointed. He thought he had done everything he was supposed to do, but the finance didn't go through. Everything that you see and highlighted is exact words that the defense is arguing to the judge. All right. They want you to think that he's a killer, he's a gangbanger, and he is not a bad guy and all that. He takes the car back to the dealership. Okay, so on the morning of the shoot, that's crazy. Like, a lot of this is typos, y'all. Against August 4th, the salesman is texting him, you've got to get the car back. You're illegal. Get the car back before we got to get the repo man. And this is like within 48 hours of the guy saying, I ain't wanting the car back. So basically, they was already on his coattail saying they want the car back. So basically, what the prosecution was trying to I ain't even gonna say those words. What the prosecution was probably trying to lean towards is that they took the car back right after the murder. But what the defense is trying to prove is that they was already on his ass days before the murder about the car. It is widely recognized that a party who raises a subject in an opening statement opens the door to admission of the evidence on the same subject by the opposing party. So basically, allowing admission of hearsay statements referred to the opening defense. Basically, these is his statures arguing why they should throw that statement out. Counsel of Robeson also put the question of lawful income at issue when he asked Special Agent Dixon a series of questions about whether FBI had investigated defendants' lawful income from rap music such as Spotify and Apple Music elsewhere. The question, you do not want to know that they're supporting themselves by out music. So basically, he arguing like, man, y'all talking about what's on paper. What about the money that they making through music, through other avenues? In some cases indicated that a door cannot be opened during opening statement because openings are not evidence. Correct. That dang. I mean, that sounds like they got this one. This is basically their argument. I don't know if y'all interested in the argument, but a lot of people really won't get a lot of this. But the Ninth Circuit Court found error where the government was permitted to introduce evidence of firearms and cocaine found in a defendant's home which were unrelated to charges at issue in the trial, citing case which specifically discussed a prejudicial. And see, that's what they're trying to, that's what I think the prosecution will end up doing if they talk about the nigga got his stuff for fraud. And that you can actually get that. You can actually get an appeal off of that if you do introduce certain rap lyrics. You see what I'm saying? So that's why if y'all been keeping up with the YSL trial, they playing a very risky game by playing that man lyrics. And I'm gonna talk about the YSL in a video right after this one, y'all. For those that's want to check that one out, I want to check something out. So drop YSL in the comment section if y'all want me to give y'all my thoughts and input on that. But additionally, in green, see, these are a whole different. This is just an argument, and I don't think y'all are really too fond about that argument. They talked about past cases and all that. So basically, this is the argument on, as you can see here, argument. We ain't gonna read that. But again, as y'all can see, this was at stake. prosecution is trying to bring in how he acquired his car through fraud and how he returned the car right after the murder. And basically, defense is trying to argue like this shouldn't be admissible due to the fact that it will lead a prejudicial thought on with the jury. Not only that, it's irrelevant to the case. So I feel as though that they stand a great chance to actually get that passed. I want to know your thoughts in the comment section below. But again, we got another court document to check out. And I just wanted to, that's 28 documents. This is that 2 we just checked out. This is the 209. It's the 209. As alleged indictment, defendants were all members of Associated. Do we see anything important in here? I'm just skimming through it real quick. Real quick. STL. This is all of. And look, everybody that keeps saying Butta ain't got no proffer, everything that is linked to anything that deals with the STL knowledge has a proffer, Santiago proffer to it, y'all. OBLOCK has year-long rivalry with STL, set Gangster Disciple, in reference to the area 63rd of St. Lawrence Avenue, Chicago. STL is sometimes referred to as Tookaville, named after Shondell Tooka Gregory, who was killed by members of Black Disciple in 2011. The rival of OBLOCK and STL has been marked by murders and attempt murders and by members of both gangs, as set out in the same detail in the government Santiago Procker in docket 191. 191 has but a whole statement in there. It got THF in there, 46. So this just a Blaine thing. They got Orford car in there, the Enterprise, but nothing really jumping out on me. I don't see no names. Yeah, this one is a no-name document. A no-name document. Hold on. Other than other charged defendants. Hold on. Prior acts of violence by the Enterprise. Other than those charged in the indictment by members and associates of OBLOCK, other than the charged defendants, the category of evidence is central of the government's case. Both because the government must prove the existence and purpose of the enterprise, and also that the defendants' charged acts of violence were carried out in order to maintain and increase their status in the enterprise. The government also anticipates that these issues will be hotly contested at trial, as defendants will argue that OBLOCK was not a formal enterprise, but rather a loose association of individuals motivated by personal, individualized vendettas. We got T. Roy in here. In terms, the government anticipates introducing evidence of 2011 of the murder of Dale Fisher. So Butta told about that Dale Fisher. While Fisher was in STL gangster territory by OBLOCK member T. Roy and others, the government also intends to introduce evidence of 2014 Jakira Barnes territory by Davon Bennett, a rapper, performed testimony that intends to produce a summary of the Santiago proffer. Again, y'all, all that is under a Santiago proffer, as the reference to T. Roy and other dead bitches on docket 191, 7-10. The murders along the government seeks to introduce at trial between OBLOCK and STL. See, Butta just did that yesterday. And again, here go the Santiago proffer on 191. Paying homage to these deceased members, OBLOCK Enterprise. Told y'all. Man, I'm gonna do a video on this paperwork alone, but I told y'all, man, Butta has a proffer. Everything that deals with everything that Butta spoke, it has the words Santiago proffer right behind it. So y'all that said he don't got a proffer, kiss my ass, motherfucker. All right, here we go though. I just scared y'all, didn't I? Here we go on this other paperwork. It's only one? 10 cents? This is just a continuation. I should have just easily been able to read that just off of that. As you can see here, continuation for today. So I'm going to get that paperwork in a second. But no, though, I just wanted y'all to peep this. As y'all can see, this is a sealed document. This is a sealed motion document. But the big O has a key card to that shit. As you can see, under seal. But we ain't going to let y'all read it. Because y'all might get whooped. Y'all might get me whooped out here. I'll let y'all check this one out real quick. Unexposed one. Hold on. Where the big one at? I think this is the big one. No, it ain't. There's some more sealed documents they let me look at. Here go a big sealed one. Under seal. The only reason why I was able to get this, though, y'all, for those that have been hitting me up, journal, all I had to do is basically, it took 2 weeks to actually get the source code, but you sign up for it. That's it. That's all you got to do. Sign up. They're going to give you a source code. They're going to send you a source code in the mail, which is going to take about 2 weeks for it to come in the mail. And once it come in the mail, you put the source code in on your court listener account, and then you got backdoor action. So with that being said, man, if y'all rocking with the campaign, don't forget to smash that like button. And the big O, gone.